Ramaphosa on Sunday, announcing that Police Minister Senzo Mkhunu has been placed on leave of absence with immediate effect. This is following serious allegations of corruption and interference in policing authorities. In a move to ensure continuity and stability, Professor Feroz Kachaliya has been appointed as acting minister in terms of Section 91, subsection 3C of the Constitution. However, the appointment has not been without controversy. Experts have already begun to weigh in, with many raising concerns about the legality and constitutionality of Professor Kachaliya's appointment. Let's now unpack these concerns with the former head of the National Prosecuting Authority, Advocate Menzi Simelane, to understand the full implications of this significant development. Advocate Simelane, very good morning to you. Thank you so much for making time for us this morning. What is it about the President relying on Section 91, subsection 3C of this appointment that makes it constitutionally suspect?
Good morning, Adrian, and the viewers. Thank you very much for having me. Well, I think the first concern that gets to people's minds is that he's appointing somebody from outside of the members of parliament, which is the general norm. But Section 98.3c allows the president to appoint at least at the maximum 2 people. So he can appoint no more than 2 people from outside of members of parliament as ministers, which is the provision he seeks to invoke now. So really all that people can check is whether or not there is any of the current lot of ministers that has been appointed from outside of National Assembly to check if the president has exercised his quota already of 2. In this case, I would imagine that that quota has not been exercised, and that's the reason why he's using that provision at this point.
Yeah. So the president indeed saying that he's relying on that section that allows him to appoint 2 people outside of the National Assembly to serve on cabinet. The debate that's being put forward by the EFF, at least, that has been charging on this as well, is that there is no provision in the Constitution for an acting minister to be appointed outside of the current ministers that are part of cabinet.
They are correct. I don't think the president is going to appoint him as the acting minister. He cannot do that. It's not in the Constitution. So the EFF would be correct on that point if that's what the president is going to be doing. I don't think he's going to be doing it. What he was simply indicating is that he would appoint a minister and then he would assign the new minister the powers of policing functions so that he becomes an acting minister. And remember, he's acting because there is in place a minister who's just not going to be absent. So it's really more the way the president phrased it, but what he was indicating was his intention. So what he's going to do in all probability is to appoint Professor Kachaliya as a minister without portfolio first, and then once he's sworn in as a minister without portfolio, and then he will assign him in terms of Section 98 of the Constitution, the policing functions, which at that time, after being sworn in, Minister Kachaliya will then start exercising from the 1st of August.
Yeah, and I guess maybe that's where the confusion for some people came in, because that Section 98, people are reading it into the president's statement. He didn't mention Section 98 in his statement, but instead just referred to, I've decided to appoint Professor Feroz Kachaliya as acting Minister of Police in terms of Section 91, subsection 3C. But the way that he would go about it is to first appoint him as a minister without a portfolio and then only as the acting police minister.
That's absolutely correct. I think the sequencing of it, the president didn't feel the need to give the details, but that's exactly how he would go about it. So if that is the case, then clearly there wouldn't be a constitutional problem from appointment point of view, although there may be questions about the presence and what basically Section 98 ultimately means, and that's where the debate is going to be once Professor Kachaliya is in place.
All right. And Advocate Simelane is looking at this appointment of a commission of inquiry. Is there anything at all that jumps at you around how the president has decided to go about dealing with the seriousness of these allegations?
Well, no. I mean, if you look at what options he had, it pretty much few options. He could have initially avoided it, but I think he took the approach that the furthest away he personally is and the members of the executives are, probably the better. Because if you remember, General Mkhwanazi's statement was basically indicting members of cabinet. So it would have been awkward for the president to then seek to use the very same mechanism that was being put into question to address the issues. So the Commission of Inquiry was actually forced on him by the utterances of General Mkhwanazi. So the president actually didn't have a choice about that. So he only had to play with the time that he gives the commission to do its business, which is not a reasonable time. In all probability, it will take longer than the time he has given it, in light of what we should expect will come out of them.
Yeah. And during that time, of course, then you will still have the police minister being on leave of absence, and then you have an acting police minister that will be taking up that role. But then the other part around this is looking at the different spheres of government in terms of the allegations that have been leveled by Nhlanhla Mkhwanazi, which includes all three arms of the state. The judiciary also implicated, the executive as well as the legislature. But I want to go quickly on to the judiciary element around it. How would Deputy Chief Justice, acting Deputy Chief Justice Nhlanhla have to navigate that particular investigation, seeing as well that these would be allegations that also implicate perhaps maybe fellow colleagues, but we know that the judiciary is implicated based on those allegations. And then on the other end as well, you have Chief Justice Maya, who had issued a statement and calling on Nhlanhla Mkhwanazi to come forward with credible evidence, not just evidence, but credible evidence.
Yeah, well, two things. I think for Justice Nhlanhla, it's not going to be too much of a problem because he'll probably start working in earnest on these issues when he has retired, which is at the end of July, in the next 2 weeks. So the next 2 weeks is going to be basically preparing the administration and all those kind of things. But the starting of receiving evidence and all of that will be when he has retired. So he'll be out of office. He'll be basically a retired Justice of the Constitutional Court. So that's not going to be a problem. So whatever he receives by way of information and evidence as a member of that commission at that particular point in time, at the end of that work in the reports would be recommendations to refer the relevant information firstly to the police to investigate, and we can assume that the police already have that information and evidence now. It's unlikely that Mkhwanazi would have raised in the issue that way without having the actual evidence. So he left the actual evidence and the information. The question would be the probity of that evidence that he will produce. In all probability, it's something that will still require further investigation. I think it's unlikely that you're going to find specifically a corrupt magistrate or a corrupt judge who would have acted corruptly during one of the matters that would have come before them inside court, because it's way too difficult. There's stenographers there who are recording. There's lawyers who are appearing, who are watching. So for Mkhwanazi to say that there's corruption, I think he made an error of judgment there, because I think he should not have been that specific when it would be difficult to produce the actual evidence. If there's a judgment that came that maybe they didn't like as the police, that they felt made the investigative work a bit difficult, all you do is you appeal a judgment like that. So you don't impute corruption or fraud or whatever. You appeal it for its wrongfulness as you see it. So Justice Nhlanhla and the Commission won't have a problem with that information. I don't think that's where the biggest problem is going to be. What can happen is that the police can produce information outside of a courtroom. So they can easily produce information that a particular magistrate or a judge, unlikely to be a judge, most likely a magistrate at this point, because of the level at which the matters are at this point in time. So a magistrate would have met with somebody outside court hours, whether in a hotel or at a farm somewhere, and discussed a matter that is coming before that magistrate in order to influence the outcome that will come. That's the evidence I'm expecting General Mkhwanazi to produce. And that would be evidence, obviously, of a witness that would have been part of that particular conversation, of that arrangement, or it would have been crime intelligence information that would have been a wiretap or sort of covert surveillance that would be produced, which intelligence is entitled to conduct in any event. So absent of that kind of evidence, then I think it's going to be very difficult on them to make that point quite successfully.
Yeah.
So Justice Meyer was correct to want to inquire about what kind of thing that would be that is alleged. And obviously, if it is there, if it's a magistrate, it will be sent to the Magistrates Commission for disciplinary proceedings to be undertaken. If it's a judge, it will be sent to the Judicial Services Commission.
Yeah.
But it shouldn't be a problem because at that time, Justice Nhlanhla would be away from the bench.
Yeah, and as we know, that this wouldn't be the first time that a commission of inquiry is actually also investigating allegations that are made against a presiding officer, whether a magistrate or even a judge for that matter. Right now, for instance, the NPA has brought a case against the suspended Pretoria Chief Magistrate Desmond Nair, who we remember also testified during the State Capture Commission of Inquiry and the corruption allegations that were brought against him. And the point here that I'm trying to bring, that it doesn't necessarily mean that magistrates and judges themselves are incapable of being influenced outside of the work that they need to do. These are still allegations, of course.
Oh, yeah, no, you're absolutely correct. Very far from it, actually. The danger with corruption at that level is that it's far more sophisticated. You can perform a function overtly in a very professional, good way. It only takes other professionals to make an observation. So, for example, an observation can be made around the pattern that every time issues of this particular nature, when they're before this particular presiding officer, this is likely going to be the line of consideration by that presiding officer, and this is likely the outcome. So from a pattern of conduct or of approach to issues, you can start feeling a bit uncomfortable about how a presiding officer is taking to certain issues. So that could be one way of starting to look at it. But it is sophisticated. But as you are correctly saying, it is not something that can be unexpected. After all, people are human beings and they have the same issues that affect everybody else.
Yeah, and then finally, as we wrap up the conversation as well, what happens after a commission of inquiry, after its recommendations and its findings? You now speak about the sophistication that is also involved in, for instance, how the money would flow, is what we've realized with the State Capture Commission of Inquiry. And Shamila Batoy always coming up to say that, listen, we don't have the necessary skills to be investigating and prosecuting some of these sophisticated crimes. How then do we make sure that by the time that you have a finding of this nature, that you have the requisite skills to ensure that there is a conviction? Because as we know that the threshold is much higher for a judgment. You need to make sure that it is able to meet the threshold of beyond reasonable doubt, unlike with a commission of inquiry.
Yeah, look, I've heard what Advocate Batoy has said on these issues, and there are different opinions on it. I differ slightly. I think there's too much being made about the difficulty of the matters generally. I don't think they're as complex as they are made out to be. That's the first thing. The second thing is that it depends again on the approach of the decision makers. The inherent problem that's always been there in the NPA, and I remember it very well, is that prosecutors generally want to make as big a case as they can in front of them. The danger with that is that you start looking for 500 charges, which makes your case problematic because for each charge, there's a lot of work that you need to do. Most of the cases that came out of the state, of the Zondo Commission of Inquiry, you already have probably 2 or 3 charges that should really be foolproof and prosecutable. So there should be no reason why people should not be appearing in court for fraud, for example, for PFMA charges, for example, for perjury, for example. So if you limit the scope of what you want to investigate, which can be 500 possible offenses, but you look at the evidence that you have and it reduces your possible offenses to 2, for me, there is no reason why the institutions should not move on the 2 that they have a better chance of proving, and then spending more time proving those beyond a reasonable doubt. Most of the time, the evidence that you have will be paper evidence, and documents don't lie. So it's either you have the document or you don't. It's either you have a video recording or you don't have it. It's either you have an audio recording or you don't have it. If you don't have all of that, Your next best evidence is human evidence, which is a witness that would have been a participant in the conduct of your investigation, or who would have some closeness or proximity to the people involved and can attest to what they did. So the less you rely on a physical human witness to give testimony, the better. But if you don't have the other documents, which are physical, then you are stretching it. If your dependence to prove a case beyond a reasonable doubt is on somebody who will have to stand up and be subject to the rigors of the court process, then your case starts getting thin. But I don't think we should accept easily that because of the alleged magnitude of the cases, they're impossible to start bringing before courts. That shouldn't be the case. There are many cases that I've observed that prima facie, the people mentioned should already be in court, at least out on bail, pending the finalization of some of the cases. It's not as bad as it is made to be. What we need to understand, and I think that's probably the Minister of Justice's area of responsibility, is to find out why there is a reluctance. And this is what General Mkhwanazi was talking about, to say when people have documents in front of them, why is it that a particular prosecutor feels unnecessary to authorize a warrant of arrest? What causes that? And that's where the inquiry needs to be, because it can be determined. The prosecutor will tell you what reservations they have. Sometimes it's a good reservation, and what you do in that case is that you simply get somebody else to give a second opinion. And in the legal profession, second opinions are standard procedure. You know, if somebody says, I have information, it's prima facie, but I'm not so sure I can get a conviction beyond a reasonable doubt, you give it to somebody else to have a look at it and say, what's your take on it? You look at it. And I have involved in cases where we've gotten somebody else to conduct a prosecution because another prosecutor would have done a good job, just doesn't feel so comfortable. So you get the one that feels a bit comfortable to move on, and you move on that basis. Most of the time, the prima facie information is there.
All right. Thank you so much for your time. Advocate Menzi Simelane, a former head of the National Prosecution.